Should states give tuition assistance to all families equally, even those that want to send their children to religious schools? Should courts be in the business of overseeing leadership decisions by religious organizations? First Liberty is asking the Supreme Court to consider both of those important questions. Hi, I'm Stuart Shepard, and this is First Liberty Live. Joining us today is Senior Counsel Stephanie Taub from First Liberty Institute. Hi, Stephanie.
Hi, Stuart. How are you doing?
I am good, except for the snow, the ice, the power outages, etc., which is why we're doing the home edition again this week. How are you holding out there?
We're doing just fine. Thank you so much for having me on the program today.
Yeah, I'm glad you're able to make time for us. This first case is out of Maine, and it involves families wanting to choose the schools that their children go to get an education. Tell us what the program is, how it works, and then tell us what the problem is in this case.
So, in the state of Maine, there are quite a few school districts that actually don't have public high schools. So, they don't have public high schools available. And because they don't have this option, instead, they give a tuition assistance credit to students, to families, to let them attend the private or public school of their choice. And they can attend any school, whether that's a public school, a private school, whether it's in Maine, whether it's not in Maine. But there's one kind of school that they can't go to. They can't attend religious schools. And so, specifically, they can't attend schools where their religion permeates their curriculum, where their religion influences how they teach the material, where their religion is actually a real part of how they teach. And so we represent two families, the Carsons and the Nelsons, that are bringing a challenge to this discriminatory policy. Because when the government opens up a benefit program to the people, they can't exclude you just because you're religious.
Now, a lot of people may not know if you've not been to Maine. A lot of it's rural, so it's very common to have communities that are away from the major cities up there. So, because of that, that's why this program was put in place to begin with, because not every community could afford to have that school. And what I'm hearing you say is you can go to any school you want unless it's a Christian school. And that's what this whole thing is about, and what we're trying to fix is that if it's a Christian school or any other kind of religious school for that matter, that they're cut out. And in the past, my understanding is the Supreme Court has ruled on a couple of on a couple cases that kind of touch on this area, and in both of those, they ruled in favor of the religious organizations being to participate in government programs. How did the appeals court get around those previous rulings? Tell me what they were and then how they tried to get around them.
Yeah, so you might remember that just last year the Supreme Court took up a school choice case. That was Espinoza v. Montana. And so in that case, Montana had this program where it was trying to help low-income students, but you couldn't use your tuition assistance to attend religious schools, which is pretty close to what's going on here in Maine.
Huh.
And so shouldn't that have resolved the issue? Well, what the Supreme Court did is they said, okay, well, in Montana, in that case, if you identify as a religious school, if you call yourself a Christian school or a Jewish school, for example, then the state said, no, you cannot participate in this program because you identify as religious. And so here, what they're trying to do in Maine is they're trying to say, oh, well, even if you identify as a religious school, then you're not necessarily excluded if you say that you're religious. But if you teach from a religious perspective, if you promote your religion, then you can't be excluded. So they're trying to create this sort of distinction between what you do. So if you call yourself religious, that's fine. But if you actually want to do religious things, then that's something we can't tolerate. So this is and to most of us who are familiar with religious education, that distinction doesn't really make a lot of sense because most Christian schools, for example, teach from a Christian perspective. And so that's going to influence what they say. So if you say you can't do religious things, that's tantamount to a bar on religious schools from participating, and that really has a negative impact on families that can't afford to pay the tuition out of their own pockets, and so have to send their kids to a school that they don't want to send their kids to just because it's religious. And that's religious discrimination, and that's what we're trying to fight.
And you're saying what I'm already thinking, and that is most regular people would hear that argument, go, I don't quite get that. But it seems to me that a key point of this is that it's the families that are choosing where this money goes to. It's not the government making the decision, it's the families making the decision. Is that correct?
Yeah, that's exactly right. So this isn't the government saying you have to send your kids to a religious school. That would be a very different situation. This is the government saying, no, you can send your kid to any school that you want, and we'll help you. But if you want to send it to a religious school, then you're on your own. Good luck. And so whenever the government is creating some sort of a neutral program, a benefit program, they can't exclude you just because you're religious.
All right. Well,
And that's the principle we're fighting for.
earlier this month, First Liberty, along with the Institute for Justice, asked the Supreme Court to take this case. What did you say to try to get them to take it?
So we're really trying to get them to close that loophole that was from the Espinoza case to really say that this status use distinction isn't there's not really a lot to it if you really dig down into it. If you're saying you can't do you're a religious school but you can't do religious things, that's the same as saying we're discriminating against you because of your religion.
All right. Well, meanwhile, I know you've been busy this week preparing another set of documents for the courts, another request for the Supreme Court to hear this other case, and that one involves a couple Southern Baptist organizations, but in particular the North American Mission Board, which all Southern Baptists are familiar with. People outside of the Southern Baptists may not know what it is, but it basically helps with church planting and also does relief work around the country. Give us a thumbnail of what happened, and then we can talk about the case and the specifics of what it is that we're asking the Supreme Court to consider.
Yeah, so we're asking the Supreme Court, we filed this request for the Supreme Court to take this case up just yesterday. And so we're asking the court to protect the principle of church independence. And so this is a fundamental First Amendment principle that says churches have the right to decide for themselves their structure, who leads them, and how they're organized. And it's not the place of the government, of courts, to go in and scrutinize the leadership decisions of churches. And so this is a case that we're asking the Supreme Court to really strengthen this doctrine and to make it clear that this is not the court's business to go in and make these sorts of, and oversee these sorts of leadership decisions of churches.
And the key thing with this one, I think, is it's we tend to get focused on the specifics of the case that this is about the person who brought the case. But really, once it gets to the Supreme Court, this is about that much larger issue of the power to make decisions as a religious organization that are based on a certain set of standards. Have I got it right?
Yeah, that's exactly right. So here, what's really important is the Supreme Court recently had two decisions that protected the right of churches to choose their own ministers, and this is broader than just a church organization, and it's broader than just the head pastor of a church, for example. So these ministerial exception cases made it clear that your churches, your synagogues, any religious organization, any religious school, they have a right to decide who leads them. They have the right to decide who teaches their faith. And so these cases are the Hosanna Tabor case and the Our Lady of Guadalupe case. And so what we have here is we have two Southern Baptist organizations who partnered together to plant churches and spread their faith. And the leader of one of these organizations expressed some disagreement with how the partnership was working, and then he was removed from his position. And so after that, and then he brought a lawsuit against the other organization, challenging his removal. And so it goes right to the heart of what those two Supreme Court cases were saying, that if you are a minister, you can't challenge your termination from a ministerial position at a church, at a religious organization, and asking the courts to oversee these sorts of decisions about why church leadership is structured a certain way, why churches want certain people leading them and not other people leading them. This is just fundamentally something we want the government to stay out of, and this is a church independence issue. But so what we're asking the court to do is to close loopholes that people are trying to get around these decisions by creatively writing their lawsuits. And so we're saying, no, this is a strong principle. We have to make sure that you can't get around it by just or by writing your lawsuit in a certain way, that we need to respect the rights of all of these religious organizations to make these sorts of decisions themselves.
Yeah, and of course, both of these, we're asking the Supreme Court to take them up. They don't take a lot of cases every year. How does it look? Do you think they'll take them up? What makes you think that these are ones that they might consider, given all the ones that are sent up there every year?
So you're right, as you might know, that the Supreme Court only takes about 1% of cases a year. So that's not a lot. They get over 1,000 petitions a year, and so we're asking the Supreme Court to take up these really important religious liberty cases. I think when you're talking about First Amendment cases and religious liberty cases, I think the court takes these a little bit more often than the regular case, and these just present such pressing issues that the importance of churches to their own to be able to decide that for their structure and leadership themselves, and the importance to treat everyone equally, whether or not when you're talking about a government program, you have to make sure that these are available equally, and you can't discriminate against people because of their faith. And these are both very important principles. We think our chances of the Supreme Court taking them up are good. We think the Supreme Court should take up these cases and protect religious liberty for all Americans.
All right. Well, Stephanie, I really appreciate the work you do. You're the best at this, and it's great that you're working with First Liberty on all these cases, that you're part of our team here. And I just want to express my appreciation for the expertise that you bring to this and the professionalism you bring to it, so that these organizations and families can have the best representation possible, thanks to First Liberty Institute.
Well, thank you so much for having me. And please go to firstliberty.org if you're looking for any information about these two cases or other cases that we're doing at First Liberty.
All right. Well, thank you, Stephanie. And hey, if these conversations about religious freedom ring true to you, look on firstlibertylive.com for the big blue subscribe button. You can see it there on the top right. And we'd love it if you would share our videos with your friends and family. You can click like and share if you're watching this on YouTube or on one of the social media channels. On our page, there's a share bar that has Facebook and Twitter and Instagram. And you can even do email if that's your thing. And share this with your friends and family. If you like these videos, they probably will too. It's also important for me to note that we are a nonprofit organization, so we're only able to do what we do because of your support. If this matters to you, if these are the kind of outcomes that you would like to see happen in this country, just go to firstlibertylive.com and click on the big red Give button. Now, we're going to see you again next Thursday live once again. We'll have attorney Leah Patterson on. We're going to talk about a juror who was kicked off of a jury because they actually asked God for guidance on how to determine what they thought about the evidence that they were considering there in front of them. I know it sounds crazy, but that's what we're going to talk about next week, and what should be done in that case. Join us right here on First Liberty Live.